Okay, then welcome everybody. This is the EU Rights webinar. Thank you everybody for attending. This session will last roughly around 1.5 hours. This webinar will provide you with an overview of the European Union settled status, or EUSS. And whilst the local cohesion teams across Gwent have prioritised awareness raising within communities, this session is specifically for service providers, those who may engage with EU nationals in the course of their service delivery. So this session is about improving your knowledge base on the rights of the individuals post-EUSS closing date, helping to avoid situations where we inadvertently discriminate citizens in a post-Brexit space. Just as a point to note, your mics are all muted, but you can raise any questions in the sidebar. We won't be discussing any specific cases this afternoon, so if you have any queries with regards to specific cases, please contact the speakers or services who will be presenting this afternoon. They'll be able to offer you more detailed guidance, and their details will be circulated shortly after this webinar. Whilst you will be aware the closing date of the EUSS is the 30th of June, so time is ticking, but there is a late application period which will run until September 2021. Applicants will need to provide sound rationale for the late application. As you can appreciate, this is an ever-changing area of legislation, and whilst the details of this webinar are up to date, I would stress to all delegates the importance of keeping yourselves updated with future announcements as things can change rapidly. Before we begin, I would like to conduct a poll to help evaluate this webinar. We'll launch a poll of 4 questions before we hear from the speakers, and then again at the end of the session, and we'll come to that in a second. One second before we do that though, Alec. Before we start, I wanted to take a moment and reflect some of the experiences we've heard from communities impacted by Brexit. Who belongs to British society and who does not? This is not simply a matter of citizenship, but relates to inclusion and culture. Brexit and the polarizing political landscape has had a huge and detrimental impact on communities, most notably EU nationals living and working in local communities, and they have experienced a heightened sense of isolation. EU nationals who have called the UK home are now experiencing a very different reality, and it is difficult to comprehend the sense of isolation that they have been experiencing by some communities. We've heard that this sense of isolation has in some cases resulted in hostility and othering. Undoubtedly, this is deeply distressing for those who are experiencing this sense of isolation. And as statutory organisations, our role is to support all communities and challenge any behaviour targeted towards others that is discriminatory or hostile. Local authorities and the communities which we support are a rich tapestry of culture and heritage, nationality and ethnicity, and we are enriched by multiculturalism and diversity, which is something to champion and protect. I'm sure you would be in agreement that we need to support minority communities who are applying for settled status, who might experience hardships as a result of these experiences. So, without further ado, Alec will launch the poll, and we'll take a few minutes to complete this, and this will give us a snapshot as to the understanding that we've gained throughout the session. Thank you, Alec. We'll just give it a couple more seconds. Okay, that's great. And like I said, we'll repeat that at the end of the session. Thank you, Alec. Okay, then we'll kickstart our webinar this afternoon, and our first speaker, Hayley Morgan from Travelling Ahead, will be taking us through the introduction to the EUSS. So, Hayley, over to you. Thank you.
Thanks, Chris. Afternoon, everybody. So yeah, as Chris said, we'll start off with a general overview. If anybody's got any questions, pop them in the chat and we'll have a look at them later on. So next slide, Alec. So what is the EU settlement scheme? So everybody from the EEA and Switzerland must apply to the EU settlement scheme, even those who have permanent residency. So this is something that that people don't often realise. They think that they have permanent residency documents and they will not need to apply to the EUSS. But unless somebody has British citizenship and they're from any of the EEA or Swiss countries, they must make an application. This also extends to children. And again, this is something that we've been coming across a lot lately, is that a lot of parents think that children don't have to make an application, but they do. So when the application is made for children, then through the documents that they will use, they will be able to see that the child is under 21, and then therefore their application can link into their parents' application. So we put on here that the scheme is free. At the beginning, a couple of years ago, it wasn't free. So we continue to tell people that it is, just in case there's some information kind of left over from before where people think that you need to pay. And importantly, the application and the proof of status is completely digital. We'll be looking at that in more detail and why that is something to be raised a bit later on. Next slide, Alec. So a few dates to remember. I think we've all had a lot of things to remember around Brexit and what does it mean and what do all these dates mean. So in terms of citizens' rights, as we all know, the UK left the EU on the 31st of January last year. And then there was a period called the transition period between that time, which ended on the 31st of December last year. This was the point when they were trying to negotiate a deal from Brexit and all the worry around that. So that was completed. And then the next deadline is to complete the EUSS application, and that is at the end of this month. So in terms of the EUSS, any citizens who arrived before the 31st of December must make an application to the EUSS, as we just said, based on nationality. But anybody who arrived after the 31st of December into the UK is not eligible to apply to the EUSS. And there are new immigration rules that people will have to follow that are obviously already in effect. If anybody's got any questions about that, then don't hesitate to ask for a bit more clarification. And again, we'll be going into more detail about it as we go on. So in terms of proving status, so the EUSS status, there tends to be quite a lot of confusion around this as to whether people need to prove their status or not before the 30th of June. People don't need to prove their status before the 30th of June. A passport still suffices, and services shouldn't be refused on the basis of whether people have their status or not. So in terms of service providers and anybody that you're working with, also this extends to family and friends. If you do support or are working with or know anybody who is from the European Union and the wider EEA community, please do ask if they have their status. It's really important at point of contact to ask that, and if people don't, rather than pointing them in the direction of perhaps the government website, please take this opportunity to refer them into our services. Our contact details will follow. So in terms of the practical steps, as I said, it is done online, and this is done by using an app and then the gov.uk website. So it's a specific app that can be downloaded, and this is used then for people to identify who they are by using their documents, so passports and ID documents. To note, this is still only available on Android phones that have NFC enabled and iPhone 7 or above. After that, then the whole of the process goes online. So somebody, after going through the steps on the app, will have a link sent to them to be able to go online. And if somebody can't access the app, so I have an iPhone 6, for example, I can't do that. It is possible then to make the application online. An update to this is that previously paper applications were made in exceptional circumstances for people who perhaps didn't have an ID document or any other complications that made them unable to be able to scan their documents. However, due to the short time frame, due to a lot of backlog in embassies and people really struggling to gain any kind of documents, a paper application is now available by email and can be returned that way. So this has really facilitated the job for many support organisations and people making applications. So we're also here to let you know that we can support people to complete applications. You know, you shouldn't be relied upon to be supporting anybody with an application or to complete that application. That's why we are here, and we're all free, confidential and impartial. Next slide, please, Alec. So as I said, the application is done online with the app and now the paper application. And so its purpose is to check identity, so that nobody else can make an application or falsify an application. Then residency, which will show how long you've lived in the UK. This will determine which status you'll receive, and we'll have a look at that in the next slide. There are 2 different statuses, and they could potentially mean different things to different people. So, and also criminality. So this is trying to find out if anybody, you know, has committed any major crimes, not necessarily any smaller ones, but it does ask on the application if anybody has committed a crime. It's really important to declare that. So what documents can be used? We spoke just now about the passport or an ID card. So this then would identify the person. But again, there are complications at present because of the backlog at the embassies. A lot of people don't have up-to-date documents because they've expired. COVID has caused a problem in being able to get more documentation together. So we are seeing the Home Office allowing us to make applications to people without that, which is a really good step in the right direction. And in terms of residency, so this is then checked by entering the national insurance number. This will check HMRC records. But if then somebody is struggling because perhaps they've got gaps in that residency, having, you know, studied or not worked during that time, it is possible then to upload other evidence such as DWP records, medical, GP letters, schools, and rental agreements. This will then prove evidence that people have been living in the country. Next slide, please, Alec. So we have these 2 statuses that you may have heard of. One is pre-settled status, and this is for people who've lived in the UK for less than 5 years. So under this, people can remain in the UK for the 5 years from arrival. And then it's a step towards applying for settled status, which we'll go on to in a sec. And under pre-settled status, you can remain outside of the UK for up to 2 years. However, when you are making an application for settled status, it will check if you were in the UK for at least 6 months in every 1 year. So we do advise people not to stay outside of the UK for more than 6 months because it will break this continuous residency. The Home Office has just released more guidance around people who've had to stay outside of the UK due to COVID, and so there are exceptions that are being looked into because of the situation around the pandemic. So in terms of settled status, then this is for people who've been living in the UK for more than 5 years, and it's like an indefinite leave to remain. So people can stay in the UK indefinitely and can stay outside of the UK for up to 5 years. One thing to note is that during the application, if somebody's HMRC records do have a gap in them, they will often be pre-settled status. If people have lived in the UK for longer than 5 years, at that point, it is possible to disagree with that, which will then prompt you to upload further evidence of residency. So who is around to support people? So we've got people across Wales who are registered to support. Just to highlight, the OISC is a regulatory body for immigration services. And so people must be registered to OISC to be able to support. If you do come across anybody who isn't registered, please do let us know. And we are all funded to do this, so it's completely free, totally confidential. All of the people listed here are currently on the call, and you can get in touch with any of us for advice and support and to refer anybody into us. EUSSWales.com has all of our details, and there will be a follow-up afterwards anyway. But yeah, please do get in touch with us. And then furthermore, this is good to note, but services are closed due to the COVID-19 pandemic. We Are Digital has been set up, and there were centres to be able to kind of have some kind of support with digital access and scanning centres for people who didn't have an iPhone 7 or above. But however, this is currently closed, and I'm not sure when that will reopen for sure. Thanks very much.
Thank you very much there, Hayley. That's really useful. And like I said before, if there's any queries or questions with regards to Hayley's presentation or any of the presenters this afternoon, then you can drop them in the Q&A and we'll discuss them at the close of this webinar. Thank you very much again for that, Hayley. Moving on to our second session then. So this is looking at the grace period. I'd like to pass you over to Eva from the Settled, who will be taking us through the grace period. Thank you, Eva.
Hello, everyone. Can you hear me okay?
It remains quite muted, Eva, but I think we can hear you, yeah.
Okay.
If you can speak up, that would be great.
Okay, I'll try not to shout. All right, Alec, can we go on slide, please, on the first one? Okay. So, when we talk about EU settlement scheme, there's few dates you have to be aware of. So we had the Brexit day, which was end of January 2020. And then we had the EU withdrawal agreement signed in January before the Brexit day. And that gave extension of EU law between 31st of December 2020 so just to give UK time to negotiate itself out of the EU. Then there was a trade deal agreement which was signed last year in December. But the withdrawal agreement, which is concerned with EU citizens' rights, then gave sort of grace period, which is now from 1st of January until end of June, because we finished the transition period end of last year. So grace period is finishing end of this month, and it's a deadline for all EU EEAs with citizens to apply into the EU settlement scheme. So we have 2 weeks. Deadline is pushing us. We are worried that many people might miss this deadline. And then I will talk about it, what it might mean later. And just to make you aware, those who you don't know, the scheme is not a paper form or card given to people. It's a digital status. And when we say digital status, it's not just, you know, that you are given one code and then you prove it. No, it's changing. It's valid only for 30 days. So you have to constantly keep looking for new codes, but Donald will talk about it later. Non-EU family members are also part of the scheme because if they can prove that the relationship was formed before the end of transition period, so married couples or couples in durable relationships, and also families, they can still apply until end of June. Okay, next slide, Alex, please. So We have a big deadline, I mentioned, end of this month, and there will be some individual deadlines as well. Grace period is sort of just to give extension. So because we ended transition period end of December, people have to be residents in the country by end of December. And if they were residents by end of December, they can still apply until the end of grace period. So that's why it means that there's been given like extended period for people to apply. Next slide, please, Max. Okay, what does it mean if people will not meet the deadline? Well, the Home Office so far has been saying that if they meet two conditions, that they have a good reason for the delay, and if they can apply within a reasonable period as soon as possible, basically. Those who fail to apply by the deadline might lose their right to reside locally in the UK. The Home Office has provided some examples of good reasons for missing the deadlines, such as children whose parent or guardian does not apply on their behalf, those in abusive or controlling relationships who are prevented from applying or accessing the documents they need to do so, and those who lack physical and mental capacity to apply. And usually the last category, that's often quite complicated. You have to probably apply through a paper form. You might not be able to do it digitally. Okay. Next slide, Alex. Alex. Right. Family members as well can still apply into the EU settlement scheme as long as a relationship existed before the end of December last year. It is different for Swiss citizens, but generally for all the EU and EEA citizens, the relationship, they have to prove that it existed by end of last year. And other family members are not eligible. So the Home Office categorizes as close family members, spouses and civil partners, durable partners, children and grandchildren, and parents and grandparents, but dependency has to again be proved. Next slide, please. What about friends and family visiting? They can still visit for 6 months. They do at the moment don't need to apply for visa. However, later on it might be that they will have to. If they do enter the country on visitor's visa, they can stay for 6 months, but they won't be able to work or study or live here using NHS and services. From 1st of October, these family members, if they want to come and visit from EU, their family members, they won't be able to use any more national ID cards. It will be only passport will be accepted. So that's nothing to be aware of. And as national ID cards, if people apply with a national ID card now into EU settlement scheme, that's okay. But it will have to be later updated to passport, because beyond 2025 national ID cards will not be acceptable under the EU settlement scheme. Next slide, Alex, please. So as Heidi mentioned, at the moment EU nationals can still work just by showing their passport or national ID card. However, more and more employers now are asking or reminding people that post-June they will have to show the digital status. At the moment, employers shouldn't be asking for proof. They can sort of remind people that they have to do it, and they can help them, maybe direct them towards services where can they get support. However, at the moment, it's not a requirement for employees to ask for it. Next slide, please. Healthcare. So residents who will have status under the EU settlement scheme, whether it's settled or pre-settled, will be able to use the NHS for free if they meet the ordinary residents. And basically, ordinary resident is a person who's normally residing in the UK, apart from temporary occasional absences, so like short holidays, that would not be counted as, you know, somebody living elsewhere. Next slide, please. Social security benefits. Those people who have settled status, that's not a problem. They have access to benefits. However, people with pre-settled status, they might have to prove their work rights before they can claim any benefits. However, there's at the moment still the court case going on, which has not been still final, so we don't know yet what on that is going to happen. However, we do feel that it's probably at the moment could be like discrimination in some cases. So just to be aware of that. Next slide, please. Okay, what is important is that what I said, we are working now towards a big deadline end of this month. However, people also will have personal deadlines to remember. Those who only got pre-settled status and will have to apply, basically not update, but apply again for settled status. They have to watch out so they don't have absences larger than 6 months in any 12-month period of time, because they will lose the eligibility for settled status. Basically, they will not have the 5 years continuous residence if they have large absences. And for example, if you look at this graph, it's at any 12-month period. So if you look at this graph, in year 1, this person had 3 months absences, and in the second year, 4 absences. So together, in any 12-month period, she already accrued 7 months absences. So people might think, oh, I'll be okay because this year I was only 4 months away. However, if they look at the 12-month period and they see that the absence was broken, then people might have to prove that there was a reason why they stayed longer. They are allowed one special absence up to 12 months when applying to settled status from pre-settled, but there has to be circumventing event, I think they call it. So it could be something like childbirth, pregnancy, childbirth, if there was a serious illness or death in a family. So things like that, but all have to be evidenced when applying for settled status why the absence accrued. Okay, next slide, Alex, please. So again, just to demonstrate as well that people have to remember these personal deadlines. This is Maria, who arrived to the UK in April 2019. She applied for pre-settled status in April 2020 and was approved in and her application was approved in May 2020. That means that her pre-settled status is valid for 5 years until May 2025. However, because she arrived in April 2019, and if she can prove that, she can apply for it as soon as she has that 5 years continuous residence. That means in April 2024. And they have to apply, people have to apply before their status run out. Next slide, please. That's it. Yeah. Thank you.
Thank you very much there, Eva. That was really useful. I'd just like to move on to our next session, and that's just discussing benefits and entitlements. David and Richard from Citizens Advice. David and Richard, can I hand over to you, please? Thank you.
Got the slides up. Okay, thanks very much. What I'm going to talk about, and it's very much a quick canter through the rules, because the rules are actually much more complicated than this might appear to be. Who is affected? Well, with the changes, it's all EEA nationals. It very much is an all change situation on the 30th of June, unless anything changes in the meantime. Next slide, please. There are still some uncertainties. We're not completely clear as well whether all the regulations are actually now in place to deal with situations post the end of the grace period. And I think, as we've already seen, there are currently no plans to extend the grace period, although there will be a period when they can look at late applications. What is very important with this when looking at benefits is that it's not the date they make an application into the settlement scheme, it's the date that is actually being granted. So we get this quite a lot where people, they've applied for settled status or whatever, but they haven't had an outcome and things have become a little bit protracted. Well, those people can't take on the settled status or pre-settled status until it's actually been granted. Okay, so it's the grant date, not the date of application. Okay, next one. Well, there are basically, for a benefits point of view, when we look at this, we're also talking local authorities' duty to provide homelessness assistance. This is in the post-COVID situation. The rules are slightly different at the moment. The EA National in Switzerland, that is, they may have been a naturalised as a British citizen or been granted indefinite leave to remain. That's a very old thing, pre-2000 probably. Okay. We've got people with settled status, people with pre-settled status, and at the bottom we got those with no settled status at all. So if you can go to the next step, please. Next slide. I'm not going to deal with the firstly British citizens. They are British citizens. They've got indefinitely to remain. They're treated as though they are British citizens, so we haven't got to worry about those. For those who have settled status, they can claim benefits and seek housing assistance under the general entitlement rules. And that will continue unless it's lost for some reason. For instance, if someone with settled status disappears for 6 or 7 years and lose their settled status, they'll go back into just being treated as the subject to immigration control. Okay, so settled status is good, like citizenship, because it gives you the most amount of entitlement. If we go to the next one, please. This is this is a bit tricky at the moment. Because there's already been alluded to, there is a court case going on. Well, there were 2 court cases going on, actually, and there's only one now. It's called the Tennis case, which is into the European Court of Justice. The government's intention is for those with pre-settled status is that they will be able to claim benefits, and when we say benefits, we mean means-tested benefits generally, provided they meet the old-fashioned right to reside tests. So I can't remember another slide for this. So for instance, they're workers or something like that, they could still qualify. And if they didn't meet the right to reside test, they were not entitled to anything at all. That was the government's aim. Some of the benefits are slightly different. Disability benefits have different restrictions, but I'll stick with the first one. The issue with what was the Fratilla case, which is now being discontinued, and the Tennis case, which is with the ECJ, is that the Court of Appeal in this country, and subject to referral from a tribunal, have queried the issue of whether someone with pre-settled status, because they have residence right, does that mean that they don't have to go through the right to reside test? In other words, pre-settled status means pretty much the same thing as settled status. Well, our Court of Appeal said that it did. So in other words, it opens up the whole benefits panoply, if you like, to everybody as if they have pre-settled status. The government didn't like that, so that's been appealed, and we are waiting for an outcome of that. But the current situation is that anyone with pre-settled status will still need to meet the old historic right to reside test. And until that changes, that's where we have to go. So if you have people who are failing the right to reside test, we are suggesting that they appeal those decisions and otherwise challenge them on the off chances that the Tennis case will work in their favour. Okay, move on. This is more tricky. This will do with people with no settled status. So come the 30th of June, if they've got no settled status at all, or being, and when I say, remember, we're talking being granted settled or pre-settled status for that matter, they will not be entitled to benefits at all, with the exception of non-means tested benefits. They might still qualify for job seekers allowance or employment support allowance based on their national insurance record, but apart from that, they will get nothing, and they will treat us as subject to immigration control. Okay, hence the reason to get those claims in. Okay, so that's the situation with no settled status. Okay, moving on. So we're basically just reaffirming this, is that, you know, there's going to be a problem for people who on the 30th of June, unless they can get it extended, is to what they're going to do, and they might very well be in some significant destitution problems if they haven't applied for it by the due date and can't get an application within the Home Office extension. It's a pretty personal view. I don't trust anything the Home Office says, but it's a different issue. Okay, move on. Wayne. Are you there, Wayne?
Yes, I'm here today. Right, well, some of the issues that we know that people are going to face are around employment, because obviously employers have to carry out right to work checks and evidence them. And at the moment, it looks like there may be some confusion with employers as to what they have to obtain and how they have to record it. Issues around housing, public and private rental sector, because obviously, again, there are requirements around proof of entitlement, healthcare and education. Next slide, please. The biggest risk in the workplace that we see is that employers are going to get it wrong, not necessarily through malice, but through ignorance, unless they are used to dealing with employees from EEA countries, then there's a good chance they could get it wrong purely because they don't know what is required of them. That's particularly true of smaller employers. So it's something we haven't seen too much of yet, but we think could become an issue. Next slide, please. That's it for us.
Hi.
Thank you
Sorry,
very much.
I wasn't able to.
No, that's fine. I was just going to introduce you there. That's absolutely fine. Thank you very much to those in Citizens Advice. I really appreciate that. Zuska Hilton, thank you very much for your attendance this afternoon. I understand that you're going to give your lived experience, so you will be looking at and discussing your experiences and those that from the Polish community in Newport have had as a result of Brexit and applying for settled status. So very, very well. Yeah, thank you very much for coming along, and over to you.
I'll give you a very quick update. I am a chair of Polish community in Newport and surrounding areas. We are sort of gathering the views of people and experiences of people before they get to the service providers. And you know, we just a second ago, there was a talk about companies not through malice but through possibly ignorance asking for the proof of status. We got to the point where we've got evidence of big companies not only asking for evidence of status, whether there's pre-settled or settled status, we actually got evidence of someone asking for the proof that the person have applied for citizenship, which obviously we notify them that this is not a case, but we're waiting to see whether we need to send it over to one of you guys. the practical impact of Brexit on EU citizens is firstly, it will be emotional impact, because we have to prove that what we do, how we live, is actually, you know, you're being basically asked to prove that you can stay and do what you've been doing for how many ever years, but now you have to prove that you're entitled to do so. I think the things that we're starting to find coming through is sometimes, albeit in unconscious bias, but there are problems with getting a job, renting a house, because the companies already know that they're not supposed to, in theory, ask for a status. But since for example, renting a house is for more than 6 months, they want people to have the status at the point of signing the paper. There were instances where people were not able to actually access the country. I don't know exact details. I am waiting for those, but from what I understand is the case of, because as you know, the settled status is only digital, and a lot of people who although applied, they were not aware that the moment you change your documents, you have to change the information in the status, because that doesn't transfer, and there were problem there already. So this is another thing that we need to get people understanding and have information of how to actually do it. We are getting into the situation of hostile environment, and we need to be very aware that this is the impact that's coming our way. And people are sometimes saying, well, I've got my home, I've got my I am the employer, why do I need this? Well, because that's the law. The other thing is, what we are starting to be asked about, especially around the pre-settled status, is to do with, right, I've got this the place to go to go to university in States. Now, can I go? Because it's 2-year course, and that means that I will not have continuous life in 5 years. This is something that we have referred to Home Office directly. So petition. The other thing that we are being asked very often is to do with the pensions, because there is quite if you think about the population of EU nationals who are here, that will be the majority of people living here will be between 18 and 65. Some of them have been here for a number of years. They're coming to the retirement age, and they would like to go back for their retirement home. And the question is, will the pension that they worked here, will that transfer? That's another unknown. One of the questions we're being asked quite often, and we refer to it as a granny's army, because obviously a lot of Eastern Europeans, including myself, when my children were tiny, my mom came over to help me so I can go back to work. Now, in theory, because this is not an employment, you can bring a granny for 6 months as long as she's not working. However, because she's a granny, because my mum was at the certain age with needs to access the NHS twice over the period she was here, but still, what do we do with Granny's Army? How do we help them? How do we go about allowing those grannies to actually be fully supported, since they are supporting us, so we can re-enter the labour market? On the point of well, you're supposed to have the status on that date. Well, all fine, but we've got a number of cases where people have applied and they've been here for donkey's years. However, it's been 8-9 months and there is no answer. We work very closely with, especially Pavlina. I referred quite a few people to Donald. We know that there are places where our clients can go, but the information in our native language is not necessarily, even if it is translated, is not translated very well. It's not plain Polish. Same as it would be plain English. So sometimes those information, even though translated, they're not really helpful. For me, that the applying for the status, it took me a very, very long time because I thought this is not fair. This is purely not fair. I've been here, I work here, my children are British. Why do I have to prove that I can still live and work here? Now, as you probably know, there is a lot more hate crime, but because of how it came about, because of the whole anti-immigrant rhetoric leading up to the Brexit campaign, people are not reporting it because they are saying, well, they just don't want us here. Who's going to take care of it? And we're talking about this being all across the board. The feeling of being different is also quite predominant in our community, and there is still quite a lot of anxiety, especially about what's going to happen later on and with kids, and just the whole idea that people are being sort of hinted to do the citizenship, which, as you probably know, is very costly. This is just not right. We are part of this community. We are part of the economic outreach. We do bring into economy quite a lot. And the fact that we're being marginalized sometimes is really, really disconcerting and really not nice. So if there is one thing I would say, please make sure that whenever you can, when you're speaking to EU nationals, please do make sure that they feel included and that you are looking out for them, because this is what we need right now the most. Thank you.
Thank you very much, Zuzka, for your experiences that you've shared with us. Very much appreciated. Session 4, I'd like to move on to, and that's looking at the digital status. Donald from Newport Mind will be discussing this. Donald, if I can hand over to you.
Thank you, Chris. So ready to start, Alec. As highlighted by other panelists, the EU settlement scheme is mainly a digital process that results in the grant of a new digital-only status, also referred to by the Home Office as an e-visa. So once an applicant is granted pre-settled or settled status, they'll receive an email with an attached letter as a written notification of their leave. It is important to note that this letter is not proof of their immigration status and cannot be used to prove their status to others. According to the Home Office, it's because this document is not sufficiently secure and should not be used as evidence of their right to work or access services. In some cases, we do always encourage applicants to keep this letter, as they can use it as confirmation of their immigration status for their own records, or for use when contacting the Home Office. It will include their application reference number and their details, so that when they're contacting the Home Office, it's easy for them to find their application. And also to note, when applicants make an application to the EU settlement scheme, for the majority of applicants, they are automatically creating a UK visas and immigration account. And the Home Office require applicants to log into this UK VI account to view and prove their settled status online. People who have settled status or pre-settled or settled status can view and share their details with others using this Home Office view and prove service. So I've got a link of it in the presentation, and once the slides go out, you'll be able to access it on the site. So this service allows people, applicants, to check what rights they have in the UK and get a share code which they can provide to anyone who's asked to see their status. The Home Office has recently announced that they will be working to provide automatic access of this immigration status to different government departments, such as the DWP, H&M Revenue and Customs, NHS England and Wales, and the Borders, Immigration and Citizenship Service. So in some cases now, applicants are asked to provide a share code. Well, after the 30th of June, in some cases, applicants will be asked to provide a share code to prove their status. However, the Home Office are looking at the future of allowing some government departments to have automatic access to applicants' immigration status, which means they won't have to generate a share code. I can go to the next one. And this is an example of what settled status will look like. So once an applicant shares their status with someone, the person will be given a share code and will have to have the applicant's date of birth. And once they enter it online, they should see a picture of the applicant's face, well, a picture of the applicant and the type of status they have. I can go to the next slide. One of the most important parts of this presentation that I would like to raise is, in some circumstances, people may have applied for pre-settled or settled status and been granted pre-settled or settled status, but they may struggle to view and prove their status online due to difficulties accessing or using the online service. As service providers, I think all of us agree that we wouldn't want a situation where someone is trying to access a service and has been denied access purely because they experience difficulties managing their status online. So I think it's important that service providers are aware of the difficulties that EU, EEA, or Swiss nationals with pre-settled or settled status may face. So this could be because of factors such as language barriers. While the majority of EU nationals may be proficient in English, a significant number of people we support speak a language other than English or Welsh as their main or preferred language and may struggle to view and prove their status online independently. This is also sometimes impacted by low levels of literacy in English, age or disability. Elderly people or people elderly people may face a range of barriers, including degenerative aging conditions such as dementia, isolation, or low literacy levels. In addition, in some cases, we found that with elderly people, some don't have access to mobile phones that have the technology that allows them to access their status online, or don't have laptops, or are digitally excluded in some cases. In some cases, we find that we often have to support people to create email addresses and to make a note of that so that they can apply for settled status. And it's also important to note that these people may struggle to access their status online. And in terms of disability, it's important to note that people with conditions involving a cognitive disability or mental health problems may struggle to access their status online, while people who lack mental capacity may have family members or carers who support them. These family members or carers may be unaware of how to access their status online. And while some people with these conditions might be able to function at work or at home, some others might still struggle to access their status online. And then the last factor I'd like to focus on is digital exclusion. While a significant number of applicants that we support report they use their access online, they're able to use modern technology for social media, a significant amount still struggle with digital exclusion, and a significant amount don't have access to the internet at home, and or maybe on pay-as-you-go contracts, so it may have limited access to internet. So with the digital only system, with an online service where people have to log in to this online service in order to access their status, this will impact people who are digitally excluded, or people who have low levels of digital literacy the most. On to the next slide. So the next question is, when can you check if someone has pre-settled or settled status? How you check an EU, EEA, or Swiss citizen's right to live or work in the UK has not changed. Even though the UK has left the EU, they can still use their passport or national identity card until the 30th of June 2021. It is also important to note that if an applicant has applied to the EU settlement scheme but not received a decision on their application yet, they would still maintain the same rights. So in some cases, after the 30th of June, some people will have applied to the scheme but not received an outcome on their application. So their rights, they would still be able to maintain the same rights they did before the deadline. So EU, EEA, and Swiss citizens who are resident in the UK before the end of the transition period have until the 30th of June 2021 to apply to the EU settlement scheme. However, as support organizations, we will still be available to support people who have reasonable grounds to make a late application after this deadline. And it is important to note that employers, landlords, and other service providers cannot require EU, EEA, Swiss citizens, or their family members covered by the withdrawal agreement to provide evidence of their status under the EU settlement scheme until after the 30th of June 2021. We are coming across a lot of people who are saying that their employers, local councils, or landlords have asked them to provide share codes or prove their status. Otherwise, they would be denied work or access to services or the right to rent. This is not correct. And even if, I stress that, even if someone has applied but not received a decision yet, they would still maintain the same rights. And before I go, I'm just going to hand over to my colleague, Anna, who's an EU national herself, who's going to speak a bit about her experience.
Hello? Can you hear me?
Yes, we can, Anna. Go ahead.
Oh, great. Well, thank you very much for having me today. This has been really, really good incomes from all the presentations so far. Yeah, Donald invited me to share with you my experience as an EU national in Wales. Well, I will do just short story of myself until now. I came to Wales in the 2018 when nobody knew anything about what would be the result with the Brexit, especially all the migrants. We didn't know anything, and it was quite confusing, everything. It was really important, more than ever, to rely in the community from the same original country. So even coming, for example, from a country like Spain, where we study English as a second language, we still don't have a really good level of English. So when you come to the UK, you feel yourself really lost, not only for the cultural barrier, but also the language barrier. It could be huge. So the support of the actual, in my case, the Spanish community was crucial. And also it revealed how a lot of people is very update about different legal implications, different resources you can access to, different community services, even before the actual people have access to the natural way of accessing to these resources. I mean that sometimes the contact of the services or the community resources are not close to the population that can do use of them. So sometimes it turned out quite difficult that. So for example, in my case, in 2019, when I started to do my application for the pre-settler status in this case, I was about to leave to Romania for a volunteering, so I didn't have any information about anything. And I didn't know, for example, that some of the organizations that are present here right now give their advice for in different circumstances. But that would be very useful if I would know, because I just was relying on people who already had the information by trying and fail, basically. But yeah, I think as Suska mentioned before, it's really important that these services make us feel that level of inclusion. I understand it's difficult, but it's true that sometimes it's difficult to reach the population from other countries. But as I said before, there could be also a low level of understanding. It happened to me in the first year, even if I understand just a little of English, you don't have the fully understanding of the stuff. So sometimes I felt, for example, in some services that I was saying yes to things that I didn't fully understand. So it's really helpful when you find someone that really care about that you are knowing and having the knowledge of what is happening and what is going on. And another thing important, I think, with the this situation now is that, for example, in the Spanish case, a lot of people is coming back to Spain, but then after a while, the situation in Spain is not better, because we are, most of the people I know from Spain, they came because the situation in Spain is really bad in terms of the work conditions and stuff. So when they come back, they find out that maybe they interrupt that continuity of living in the UK, or that maybe they are not allowed anymore for the pre-settled or settlement status. So I think there is a lack of information on that for everybody. And even with the great effort that all the organizations like this one today here, people still not have enough access to all the conditions and the repercussions. Thank you. Thank you so much.
Sorry, I forgot to say as well, for anyone who comes across an EU, EEA or Swiss national who thinks they have status or that they have applied and is unsure or may have difficulties proving their status, you can refer them to one of the organizations mentioned on the panel, and then we can support them to view and prove their status. Or if they haven't received a decision yet, we can support them to contact the Home Office to chase up an application. If they haven't made an application, we can support them to make a late application if they're eligible. So I would encourage that in cases where you come across any EU national where you're unsure if they've made an application or they haven't made an application, please make sure to refer them to us, because we're happy to help. Thank you.
Thank you very much there, Donald. And also thanks to Anna for sharing your lived experience. Many thanks. We move on to the fifth session, and it's the last session. So I'm going to pass over to Edward and Alicia from Newfields Law, who will be discussing myth busting.
Hi, can you all hear me okay?
Yes, we can. Go ahead.
So yeah, I'm Edward. I'm a paralegal at Newfields Law, and I'm also here with Alicia, who's also a paralegal at Newfields Law. So, go ahead, Alicia.
Cheers.
So we have sort of produced a couple of slides with myths that people generally believe about the EU settlement scheme, in the hopes that this could answer a few people's questions and potentially sort of provide a lot of clarity to the EU settlement scheme. So if we could go to the next slide, please. So if I don't have a national insurance number, I cannot apply to the EU settlement scheme. So this is wrong. You can still apply to the EU settlement scheme, even if you don't have a national insurance number. This has been especially prevalent given that a lot of individuals haven't been able to get new national insurance numbers because of COVID. So if you don't have a national insurance number, even though it asks in the application, you can just select like no national insurance number in the application, and you can evidence your residency in other ways using other documents. For example, payslips, P60s, P45s, a contract or letter from your employer, an enrolment letter from your university, bank statements, utility bills, GP registration letter, council tax bills, and a tenancy agreement and corresponding rent payments. If you have any difficulty collating this evidence together, feel free to get in touch and we can provide some assistance. And if we go to the next slide, you go ahead, Alicia.
Yeah, so children do not need to make an application where their parent has applied. Again, this is wrong. So a child still must apply to the EU settlement scheme. They must make their own individual and separate application. They can then link their application to their parents to receive the same status. So here we would advise that the parent applies first. You know, they could have just made the application, that they don't have to have had an outcome given yet, but then after the child to make an application and link with their parent, they do this via the 3434 number that is given through the parent's application, and then you link to show the relationship. So this could be through a birth certificate showing both names. So yeah, just to recap, children must make their own application for the scheme, but link it in with their parents' application too.
So once I have pre-settled status, it will automatically update to settled status after 5 years. So this is wrong. After residing in the UK for 5 years, you will then need to reapply for settled status yourself. So for example, if you came to the UK in December 2020, you would need to have applied for pre-settled status before the 30th of June deadline. And then once you've accrued 5 years of residence, you can then reapply for settled status. So that would be in December 2025 that you can then reapply for settled status. If we could go to the next slide. Oh, thanks.
If I have criminal convictions, I would not be able to get a status under the EU settlement scheme. This is wrong. You may still be able to get a status under the scheme, even if you have criminal convictions, but this is all dependent on what this is. The most important thing is that you disclose any criminal convictions. So this is whether it's previous, current or pending, whether it's in the UK or overseas. It's important that you kind of disclose anything and show honesty in your application. Criminal checks are made on every application made to the scheme. So if you do have this, it's important that you disclose it at kind of first instance of where they ask this when you're applying. So no, it's not necessarily the case that if you've got convictions that you won't be awarded a status. It's just important that if you do have this, that you detail that, and then this will then be reviewed by a caseworker at the Home Office. Next slide.
So once I have applied to the EU settlement scheme, I should receive a card to prove my status. So EU, EEA and Swiss citizens will not receive physical proof of their status. They can prove their status online, as mentioned earlier by Donald. However, non-EEA citizens will receive a card. If they already have a biometric residence card, they need to transfer this from their current residence card to the EU settlement scheme, and they will then be sent out an updated card. If we go to the next slide.
So if I'm an EU citizen and married to a British citizen, I do not need to apply to the EU settlement scheme. So again, this is wrong. So you would still need to apply to the scheme if you are in fact an EU citizen. You're obviously solely relying on your own residence and nationality to make an application. The only difference is that if, for example, you're applying for settled status as a European citizen, where for most applicants, if you're an EU citizen applying for settled status, 12 months after being granted the status, you can then apply for British citizenship. The only difference in this scenario is that if you're an EU citizen applying for settled status and married to a British citizen, then you won't need to wait 12 months to make this application. If you so wish to, you can kind of do it straight away. That's the only difference. But again, if you're an EU citizen, you do need to apply to the scheme before the end of this month, relying on your nationality and residence in the UK. Next slide, please. Thank you.
So my employer can end my contract after the 31st of December 2020 if I have not yet applied to the EU settlement scheme. So this is wrong. At the moment, pre-30th of June deadline, all an employer can ask for you to show your right to work in the UK is your EU, EEA or Swiss passport. So individuals who have not yet applied to the EU settlement scheme can continue to work until 30th of June 2021, at which point they will need to have made an application to the EU settlement scheme. So you need to have made your application before the 30th of June. You don't necessarily have had to receive an outcome before 30th of June. If an employer asks for evidence after the 30th of June that you've got a status, you can either use the share code online or you can use your certificate of application, which shows that you've applied and you're still awaiting an outcome. So if we go to the next slide.
If I do not have an identity document, I cannot apply. Again, this is wrong. Due to COVID-19, we know that many applicants haven't been able to make an application because their ID documents have expired. So where this has happened, they can still make an application, but it's just through a different format, and this is using a paper form. So a couple of things here. One, an ID document may be expired. However, there have been given expiry extensions through certain countries, so not all. We can put a link in later for the expired documents, realigned expiry dates for this. Our website detail what countries this falls under. However, if not, you essentially make a paper application form. Recently now, this has now changed. You can actually apply for this form through email, which makes it a lot quicker and easier as we're approaching the deadline. So essentially the paper form is the online application, but in paper format. You make the same application, give the same information, same residence, evidence of residence. However, in this way, you would actually have to explain why you've not been able to use the online application. So more commonly here, you would evidence that you've not been able to book an appointment due to embassy closures from COVID-19, or for example, you've got an appointment booked, but it's post deadline, so obviously you can't wait until after to make an application, so that's what you're doing now. Obviously this type of scenario is a little bit more complex rather than the online application, so feel free to get in touch with any of the organisations on the call today, and we'll be able to help assist you with the paper form. Whether you just had a query or actually needed some one-to-one help with this, we'll be able to help you.
So if I have permanent residence, I do not need to apply to the EU settlement scheme. So this is wrong. Individuals with permanent residence do still need to apply, and you can provide evidence of this permanent residence in your application when you do apply. So in the application, there's a part of the application that asks if you have a permanent residence document, and then you can put in the document number, and this will then sort of register in the application. So if we can go to the next slide.
So I've been working or self-employed for 5 years. I have to be working, sorry, or self-employed for 5 years to be eligible for settled status. No, this isn't the case. The EU settlement scheme is based on one's residence in the UK and not whether you're working. When making the application, for example, in a paper form, you can kind of disclose that you've been working, and through a kind of evidence of residence document being your national insurance number, this can be useful to show that you've been working and contributing whilst living in the UK. But as Edward said, with the national insurance, even so, you don't have to have been working at all in the UK to be eligible to apply under the scheme. It's purely based on your residence in the UK. And the main point is that you must have been resident in the UK before the 31st December 2020 to be eligible.
And thank you very much both for that presentation. And that actually concludes the session, the webinar this afternoon. So we have some time available to us now for questions and answers. And if you do have any queries, then by all means post them in the Q&A chat. We've already had a few that have been answered throughout the webinar, so we won't recover those. But if I could just remind delegates to keep your queries more general. If you do have anything specific with regards to cases or your own personal circumstances, then I would kindly direct you to the speakers of this afternoon session, and they'll be able to give you more personal advice. So we'll just leave that open to all delegates. If you've got any questions, then pose them in the Q&A, and yeah, we'll cover those off in a second. I give it sort of a minute. Nikki, yes, the PowerPoint or version of the presentations will be made available, as will the contact details of all of the agencies, organizations and speakers that are presented this afternoon. We'll circulate to that probably tomorrow. Fighter, just coming back on your question there in relation to your personal circumstance. So what I would advise you to do is to get in contact with the speakers of this afternoon session, and they'll be able to pick that up with you at that point. Okay, there's no further questions. We won't leave it any longer, but what I'd like to do now is revisit the poll that we carried out at the beginning of the session. Alec, it will be the same question for delegates. Perfect. Alec is just putting it up there. If you can mark your scores for those same questions, and we'll leave that open for a couple of minutes. We'll just leave that run for one more minute. Okay, fabulous. Thank you for those that have engaged with that poll. You can end polling now. Thank you, Alec. And I would also just like to thank again all of the speakers for attending. I do appreciate your time, it's very precious, but I found this very, very useful. So, and I'm sure the delegates have as well. So again, thank you very much to everybody that's attended, and I wish you well.
Thank you.
Thank you.
Thank you.